Today's webinar brought to you by OraSure Technologies. OraSure Technologies is a global leader in oral fluid substance abuse testing products. Their unique assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Fluid-based testing products provide a simplified collection process, faster results, cost savings, with minimal risk of adulteration, and reduce. The Intercept Oral Fluid Drug Test is an FDA-cleared, laboratory-based oral fluid drug testing system that enables accurate testing for 9 drugs of abuse, including marijuana, cocaine, PCP, amphetamines, methamphetamines, barbiturates, benzodiazepines, methadone, and opiates. It was #1 recognized brand name in oral fluid testing in a 2016 National Drug Testing Industry Survey. With fast and easy to administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, and clinical setting screening programs, among others. Today's presentation is entitled The 2016 Legislative Update and will be presented by Andrew Current. Andrew Current is the Compliance Director for the Current Consulting Group. He specializes in domestic and international drug testing laws, compliance research, workers and unemployment compensation, legalized marijuana, and legislation in progress. Andrew is the planning, research, editing, and distribution of CCG's monthly and quarterly publications such as State Drug Testing Laws Monthly, as well as CCG's other publications. It will now be our pleasure to hear from Andrew Current.
Introduction. Just wanted to show you a quick slide to chooseintercept.com and wanted to say thank you to OraSure for hosting today's webinar. And skip over my slides since Jessica already went. And when you're learning how to print, they always say you're going to talk about it, and then everyone what you just talked about. So here we're going to talk about, before we talk about it, we're going to go over part 1, new legislation passed in 2016, and a wide-ranging topics from workers' compensation, DUI testing, welfare drug testing, synthetic drugs, all of these being laws that were passed in state legislatures throughout this year. Part of new marijuana laws, and those are going to be bills that were passed by state legislatures, as well as the states that voted and approved medical or recreational marijuana laws in November, which was a lot of attention, and we've been talking a lot about it since November, as well as some lesser known and less discussed marijuana laws have been passed in 2016, like right to try laws and what exactly a right to try law is. After that, we'll spend a brief amount of time on the injury reporting and drug testing implications. Of course, this wasn't a law that was passed, but it's a new regulation, and even though it doesn't specifically, in language of the regulation, or restrict drug testing, made it pretty clear in the preamble to this regulation and the memos that have followed the regulation how it intends to use kind of the open-ended language of the regulation to regulate drug testing practices. So we'll get into that a little bit towards the end. And very quickly, part 4 and 5, some items for 2017, how you can get more involved in the legislative process with me and as an individual, and then if we have time at the end, we'll take some questions and do it. So let's start off a little infographic that we've prepared. Current Group, we have a series of infographics and articles that we're preparing, and this is an excerpt from one of those infographics that summarizes the massive amount of change that happened in 2016. So like we alluded to earlier, 9 states legalized some form of marijuana. So those at the ballot, for those in the legislature. 15 states amended existing marijuana laws, and some of those are basic changes, well, not basic, but retail, honestly, boring changes to tax code, zoning laws, how you get approved to become a facility. But some of those have potential to impact how lawyers are allowed to or required to regulate drug marijuana use in the workplace. So it's important to keep, even though Alaska and California and some of these other states have passed recreational marijuana laws, it's important to keep up to date on what's happening in those states, because those workplace provisions that we see are subject to change. 2016, the US DOT random drug testing rate of 25% went into effect, and we saw this announced last year. It went into effect in 2016, and at Current Consulting Group, in our drug testing industry survey this year, we saw that a large number of employers are continuing to test at the old rate of 50%, but a large number have also dropped down to 25% for the random drug testing rate. And they talked about already just a little bit, announced a rule for reporting injuries and illnesses that have impacts into drug testing, post-accident drug testing. And look at the bottom, it's interesting to look at year over year, the bills that were introduced and passed. A little bit hard to see, it's a little bit more non-exact representation. Just to give you a general idea, 2014 and 15, we saw more or less around 225, 250 laws introduced. But in 16, we saw nearly 300 new laws, or bills, new bills introduced to the legislative level. And if we go over to the side, we see how many of those laws actually, our bills actually became laws. So 2014 and 16 looking pretty very close, around 30 or so. But 2015, we saw under 20. So it was a very, very slow year, and it picked right back in 2016. So it just goes to show that look forward into 2017, these bills that are introduced that are pertinent to drug testing, how many of those become law? Really, it can go all over the place. Next year could be a really light year, or this year could make 2016 look like a light year in comparison. So we'll get into examples and reviews of the new legislation that was passed. So here are states that passed legislation, consumer testing or workers' comp or something in one of those realms. The winner, if there is a winner, it's District of Columbia with 3 laws that were passed, whereas all the others we see 1 or 2. So no state is a knockout winner. We're not seeing massive amounts of change in any single state, but to the whole, we see a lot of change in 2016. However, the types of laws that were passed, there is one contender that just goes above and beyond all the others, and that's marijuana laws. So we saw 14 states changed existing marijuana laws. Well, that translates into 19 different bills that became laws. So some of those states had more than one marijuana bill become a new law. I also see 3 controlled substances laws, so updating controlled substances lists at the state level, 5 DOID laws, and we'll get into an example of one of those, or a couple of those actually, implications. We see, interestingly, 2 synthetic drug laws were passed this year, and the interesting thing about that is just how much synthetic drugs have less spotlight, so to speak. It used to be, 2, 3, 4 years ago, it was all you heard about on the news. We could have done 2, 3, 4 hour long presentation just on synthetic drug laws that came and went. This year, it's kind of, a trickle of 2 laws. And next, welfare drug testing, it's the same issue, or same type of story. A few years ago, we could have spent an entire presentation just talking about all the different welfare drug testing laws that were introduced, passed, or failed. This year, one of them ekes by. It's because there's not as much controversy, so there's not as much challenge to these because it's not as exciting to hear about the same topic in the newspaper year after year. So newspapers aren't reporting about these things, and TV news isn't talking about them. So we're not seeing as much synthetic drugs and welfare drug testing laws discussed and passed. But the issues with synthetic drugs are still there, and the advantages but also the challenges of welfare drug testing are still present. Move on, and we see 2 workers' comp drug testing, our workers' comp laws relating to drug testing, which we'll look at, 3 other types of laws on various topics, tangentially related to drug testing. So the one that we're going to look at is actually workers' comp premium discount law, Maryland Senate Bill 505. And what's interesting about this is that it creates a workers' comp premium insurance discount program that insurers can establish on their own, and they offer up to a 4% discount. And they do this for any one of the following programs or a combination thereof. So drug and alcohol testing, employee education, supervisor training, employee assistance, post-employment rehabilitation, or any program that the insurer deems effective for reducing risk and increasing safety. So that's very interesting to see kind of this fair approach to workers' comp premium discount, create the program and let insurance providers do all the details and take care of all the approval and elimination process with employers and all the policy verification. Let all of that be taken care of by insurance providers and their clients. It's very interesting in the OSHA regulation that came out this year, which we'll get in a little more detail later, but OSHA said that they are to cite employers who use post-accident drug testing as a form of retaliation and punishment for reporting injury. The logic that has come out of that is that if you are complaining with a state drug testing law or federal drug testing program or an insurance premium discount program, for example, the obvious motivation for that post-accident drug test is compliance with the program to get a certain incentive. And so those kind of programs will be subject to citations from OSHA because it's punitive retaliatory action to do this drug test if it's the workers' comp premium discount program that your insurance provider has offered to you. So this is very interesting and very good news, especially in 2016 with what's seen happening with OSHA. Workers' comp, let's go Senate Bill 214. This one, just to make the distinction, the last one was a workers' comp premium discount. This workers' comp claim reduction. And so just, we're keeping our tomatoes and our tomatoes separate, right, is workers' comp premium discount is a discount on your insurance premium that you pay to your insurance provider. The workers' claim denial or reduction law is when an employer in the workers' comp claim, if drug use and intoxication was the cause of that injury, the employer can show evidence and use or deny that claim. It wasn't the employer's fault, it was actually the individual's fault. So this replaced a previous claim denial law that allowed for 100% denial of a claim if drug use, intoxication, impairment, etc., was the main cause of the accident. That is done away with, and now there's this sliding scale where 10 to 90%, depending on how much the drug use played a role in contributing to the accident. Even if it's 100% the fault of the drug use, the maximum reduction now is 90% instead of 100% denial. So it's good this is still here, that they didn't just get rid of it, but they've taken away a little bit of that incentive to employers to comply with the law, because no matter how good your program is now, you're going to Bill 214, you're always going to be liable for just a percentage of that claim. And it doesn't get into the intricacies of, how much does the insurance provider cover, hunted back over to the employer, but just overall, there's that little bit of financial liability now built into the law. So it's a little disappointing, but as well, this new law, Senate Bill 215, adds in testing requirements, which we didn't see in the last one that we looked at, but in this one, it requires laboratory testing, restricting to urine, blood, or brand blood, requires a specimen, and requires a written policy with notification prior to testing. As well, caveat, if an employee refuses to submit to drug testing, it can be denial, or then the claim can be denied 100%. So interesting evolution, and we'll see, hopefully this isn't a trend towards claim rejection laws instead of claim denial laws, but this is kind of a unique law that we don't see a lot of. If we can sum up synthetic drug bills, our laws, in one page here. Illinois, Kentucky, Nebraska. Illinois and Nebraska added more synthetic compounds to their controlled substances list. Kentucky had a law increasing penalty for possession or trafficking of synthetic drugs. And so perhaps, I don't know, because it's a complex issue and it's hard to synthesize that all at once, but perhaps the response and the strategy has shifted from lawyers to law enforcement. And maybe that's why we're not seeing as many synthetic drug bills, or maybe it's because, places like Miami, where we used to see daily people coming into hospitals and control centers with synthetic drug overdoses. Now the problem has almost entirely disappeared. It was something like in January of this year, they had 4 cases in Miami compared to 50 cases a month in 2015. So the problem has evolved and switched, but it hasn't necessarily gone away. And that's the interesting thing, is that some of the numbers indicate that it's not a problem in South Florida, which was all in the news with zombie synthetic drugs and all that stuff. There's an increase in synthetic drug use in other parts of the country, like the Northeast. So it's an issue even being addressed by lawmakers, and that kind of creates an imperative and a responsibility for the drug testing industry to educate clients on the fact, even though it's not in the news and it's not on TV, that synthetic drug abuse is still a danger and a risk to workplace safety. Makes sense. We had 7 laws voted on for marijuana this year. We have increased opioid and prescription drug abuse going on, a lot of attention. So it makes sense. There's just many other things gaining attention from the media that, that synthetic drugs might be seen as old hat, so to speak. But we've got 2 interesting DUI or DUID laws. So in Senate Bill 207 added an oral fluid drug testing kind of pilot program for roadside DUI testing. So trained drug identification expert, they see the signs, they can hire someone to submit to an oral fluid test there on the spot. And the interesting thing is that even though it's instant oral fluid instead of light oral fluid, the law classifies the results as admissible for use in court. So while drug testing industry has seen for a long time the validity and the legitimacy of oral fluid drug testing, it's interesting to see how other realms, other zones of society are starting to recognize that and set up more programs to test out oral fluid in other situations. And so this is one of them. Other bill, Washington House Bill 2280, makes driving under the influence of marijuana a felony. And that's interesting, given the fact that if you look at the facts, driving, specifically marijuana-influenced drivers, have been increasing in places like Washington. Just in 2016, AAA released a report and an infographic of theirs, which I've kind of sliced up and zoomed in on for you. In 2016, AAA came out with this report showing that drivers involved in fatal crashes recently used marijuana doubled 2013, before legalization, and 2014, the year of legalization. And 14 is the most recent year of that we have. So we'll see what happens when the 2015 data comes out. But it's just not a coincidence that in 2016, I see this marijuana DUI felony law. And it's interesting because as well, as part of this survey, AAA said, despite how dangerous this is, 6 drivers involved in a fatal crash recently used marijuana. And as big of a deal as that is, they came out and said the science doesn't yet support a THC cutoff level for DUIs. So while debate is roaring, so to speak, about what legal cutoff, scientific cutoff for THC in driving will be, at least we're seeing some state lawmakers take a reasonable, sensible approach to driving the influence of marijuana. And, it's sort of like, someone brought up the other day, maybe marijuana is a raccoon and alcohol is a wolf. A raccoon's not as dangerous as a wolf, but you still don't want raccoons, in your house. So even though some may say marijuana isn't as responsible for fatal car crashes as alcohol, it's still dangerous, and we still need to address that problem. So it's at least encouraging to see that in states like Washington that have pioneered recreational marijuana use, we're seeing them pioneer strict civil measures to control driving influence of marijuana in their state. So it summarizes the most pertinent and kind of the most tidbits, to speak, of legislation passed in 2016, which leads to what will happen in 2017. Surprisingly, California and Maine have already started their 2017 legislative sessions. Just last week, I think it was December 3rd, was the state, which was Monday. That was like what date it was. See the vast majority of states and territories like District of Columbia, Puerto Rico, Guam, and 40 other states starting in January. We'll see a huge boom in the number of new bills introduced in January. And then a few states start in February, and then Florida and Louisiana start in March or April. First, we have the U.S. Congress starting January 3rd. So, we said earlier, it will be interesting to see if this is a really busy, tense legislative year in 2017, following 9 brand new medical and recreational marijuana laws in 2016, or it will be kind of a kind of lull or a you see less activity like in after we had a big movement in 2014. So we'll have to see, but a lot of things will be moving shortly. So we can look at new marijuana laws from 2016. Before we get into the ballot initiatives that were passed, let's look at the bills that were passed by state lawmakers. Ohio House Bill 523 was passed April 14th of this year, and it says nothing in the law requires an employer to accommodate use of marijuana in the workplace. So it creates that, employers don't have to accommodate drug use in the workplace. They have to be tolerant of drug use out of the workplace. The law adds, so for employers hiring or refusing to hire, charge, discipline, discriminate, retaliate, or otherwise take adverse action against an individual because of that person's use of marijuana. So while the first provision of that law seems like it's limiting the scope of what employers can do, the second provision of the law creates protection for employers who take adverse employment action because of someone's medical marijuana use. So there's no that balancing of these two provisions. Individuals discharged from work because of medical marijuana use are considered to have been discharged for just cause. So that's interesting if we get into things like unemployment compensation, which, if an employee is discharged from or let go from employment for cause, and they are possibly not eligible for unemployment insurance benefits. And the law adds again, nothing in the law prohibits an employer from establishing and enforcing a drug testing policy drug-free workplace policy or zero tolerance policy, and that comes straight from the law itself. So while that first provision kind of adds in that restriction of in the workplace, the rest of the provisions of the Ohio law really make it clear that employers can continue to enforce their drug-free workplace policies, including drug testing. If Pennsylvania, that was the other law, medical marijuana law, that was passed by state lawmakers this year. And Bill 3 was passed very close to Ohio, Ohio's bill, April 17th. And this one is kind of like a puffer fish. It looks a lot more menacing than it really is. It's like a puffer fish. If you get a good cook, very skilled and knows what they're doing, they can cut through it just right to get to the part that you can actually eat on a puffer fish. But with this Pennsylvania law, if you can cut through the law with precision, with careful, there is a route to drug testing and a drug-free workplace. So nothing in the law limits employers' ability to discipline an employee for being under the influence of marijuana in the workplace or being while under the influence of marijuana if the employee's conduct falls below the standard of care normally accepted for that position. So essentially here we see kind of provision that we haven't seen in a lot of other laws so far on marijuana, where it's but if an employee's conduct falls below whatever standard of conduct you require of your employees at work, the marijuana use, then an employer is justified in disciplining that person. So again, this is a pretty interesting route because a lot of the laws just say an employer can't discipline and discriminate against someone just because they have the marijuana card. Well, this says if the conduct falls below a certain threshold that you determine as the employer, then you can discipline them without any problems. And that's pretty encouraging. It gives the power or the decision back to employers that their workplace requires. However, if we look midway through that workplace paragraph, an employer may not discharge, threaten, refuse to hire, or discriminate or retaliate against an employee regarding an employee's competence terms, etc., based on employee status as an individual who's certified to use medical marijuana. So actually, what these provisions are doing, the way that I read it, is require an employer to give medical marijuana user the benefit of the doubt, but if their conduct falls below the standard that they require, then, can do as they normally would for anyone else who's not meeting the standard of conduct required for the job. Kind of require employers to play nice, give everyone a fair shot, as see it. It means that employers still have that right to have a drug-free workplace policy. And not explicitly addressed in the law, it definitely is a possibility in the way that I read the law. However, let's see, what I say here. This an imperative for employers to create kind of that criteria ahead of time and make sure that their policy states that criteria very clearly, and that criteria is documented when incidents issues arise. And we see this recurring in a lot of these other marijuana laws. We'll see this when it comes to OSHA. The days of by the your pants drug testing programs, if those days ever existed, they're definitely on now. There's no more leave it up to, benefit of the doubt. We'll see how this plays out with the policy in place. Now, whenever employers have an obligation to put these things in writing explicitly ahead of time. So we're going to look at ballot initiatives now. We'll play a little game like, when you're at the doctor's office as a kid and you pull open that magazine, the left picture and the right picture, and what changes. So before the election, here's after the election. Did you see what changed? We'll go again. Here's before, here's after. The one probably noticed, first of all, is a lot more dark green, right? If you look more closely, you also notice a little bit less gray and a little bit more light green. So I won't ask for anyone to raise their hand or tell me how many they got wrong or right on the little game. We'll just move on at it in more detail. But the first one, if you spot it, was Arkansas. So Arkansas Issue 6 was a constitutional amendment. And I'll stop right here for a second just to explain why it's important to say that this was a constitutional amendment. Is the difference with, there are basically two routes to law. There's the Constitution, and then there's legislation. Constitution can only be amended by the people through a vote. As legislation, whether voted on by the people or voted on by lawmakers, can be amended as soon as the next bill comes to the legislator. They can vote on it, and the old law passed last week is gone. Whereas a constitutional amendment, if it passed in November, the soonest anything can happen to it, can be repealed or modified in the Constitution is there in November when the election rolls around. So this is a tactic that we, from the pro-legalization people, if they get, by the hair of their teeth, skin of their teeth, if they can get a constitutional amendment passed, it's basically going to stay there. It makes it so much more difficult to repeal it or to change the actual wording of it. So we'll see constitutional amendments, we'll see just laws that were passed, and that's the difference, and that's why we're taking the time to talk about it. So how does Issue 6 impact the workplace? From the constitutional amendment, it says this amendment does not require an employer to accommodate the ingestion of marijuana in the workplace, an employer working while under the influence of marijuana. So that first provision has limitation of in the workplace, but the second provision doesn't. Employee working under the influence of marijuana, that's a general thing. So whether they're smoking outside of the workplace or whatever it may be, if they're under the influence at work, employer is not required to accommodate that. However, we can kind of apply to drug testing this next provision, which says an employer not discriminate against an individual in hiring, termination, or in condition, term or condition of employment, or otherwise penalize an individual based on the individual's past or present status as a qualified patient or caregiver. So here we again kind of that obligation for employers now to establish criteria of reasonable suspicion, standard of conduct, and how marijuana might impact that standard of conduct, and get those things documented in writing before terminating or disciplining an employee for marijuana use to avoid accusations of discrimination, which are built into the law. Look at Florida. Florida Medical Marijuana Legalization Amendment 2. Nothing in this section will require any accommodation of any on-site medical use of marijuana in any place of employment. This is a step in the right direction, but all it does is say that employers aren't required to accommodate smoking marijuana at work. It doesn't talk about being under the influence. It doesn't talk about drug testing. It doesn't talk about, drug-free workplace policies. It just says you're not required to accommodate if they want to smoke at work. So it's there, but it's a bridge not far enough to kind of turn that expression on its head a little bit. So unclear how exactly this will interact with the Florida Workers' Comp Premium Discount Law. We know for sure, though, that this will have an impact on DOE or other federally mandated drug testing programs in Florida because, as very clear, marijuana could be a violation of its drug testing policy, regardless of what state laws are passed. If Dakota, Marijuana Legalization Initiative, interestingly, it doesn't say anything about the workplace, accommodation, discrimination, nothing. So, have a double-edged sword. It doesn't really restrict employers at all, but it doesn't protect them. At the same time, it doesn't offer any protection to marijuana users either. It's a lot of let's wait and see how it works itself out. Moving to recreational marijuana, California, Position 64 makes sense to the Health and Safety Code. So, again, since this is not a constitutional amendment, the actual language of this law can change very easily. Like we just said, California's legislative session started just last week and introduced any laws to amend this new law, but they could at any moment add in a new law that takes out these provisions and replaces them with different provisions. So that's the importance of keeping very up to date with legislation comes into play. Even it's like a lot of work, but it is very important, especially with all new marijuana laws and the regulations and all the follow-up that comes with it. So interestingly, even though California is seen as kind of the progressive state, it has a very clearly pro-employer provision. So it says nothing shall be construed to affect, restrict, preempt the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace. And if we get down, it says, or ability of employers to have policies for the use of marijuana by employees and prospective employees and employers from complying with state or federal law. So this absolutely leaves the door wide open for employers to continue their drug-free workplace policies. It doesn't change the fact that there's a very extensive network of drug test-related case law that employers need to be very well aware of when testing in California. It doesn't change the fact that, for example, Cisco has a somewhat restrictive city drug testing law, but the recreational marijuana law doesn't affect that existing framework, which is hopeful or positive. Main question. Chapter shall not be construed to require an employer to permit or accommodate use, consumption, possession, trade, display, transportation, sale of cannabis in the workplace. So again, we see this provision limited to in the workplace, but this chapter does not affect the ability of employers to enact forced workplace policies restricting the use of marijuana by employees or to discipline employees who are under the influence of marijuana in the workplace. So it's important there that the in the workplace comes after the or in the second sentence. And maybe it seems like too much semantics, but this is the nitty-gritty of what decides, makes or breaks a policy, makes or breaks a case the judge is ruling on, is this semantics. So an employer can restrict use of marijuana by employees. This new marijuana law does not affect employers' ability to do that. Some people think that the word restrict is a little wordplay by the pro-marijuana people, because you can't, restrict is not prohibit. Well, in mind, I don't know if my arms are restricted in a straitjacket, I can't move them. So what's the difference between 100% restriction and prohibition? I don't see the difference. So we'll have to see, if people start making these nitty-gritty semantics-based arguments in court, if the courts need to use kind of a common English definition of restrict, or need to learn a new definition of the word restrict that only applies to marijuana. Moving on, though, despite that kind of hopeful, mystic provision, it'll also add in an employer may not refuse to enroll employee or lease. Oh, sorry. I'm going to read the bold language there because that's what applies to an employer. Employer may not refuse to employ 21 years of age or older solely for that person's consuming marijuana outside the employer's property. So here we have this conflicting provisions. At one point, it says the employer is not affected in its ability to enforce workplace policies that restrict marijuana. But at the end, it says the employer cannot refuse to hire someone, even if they know, because of a pre-employment drug test, because of, other things and revelations that come up during the pre-employment process, they know is not going to live up to their drug-free workplace policy. Someone they know is going to violate the policy, can't refuse to hire them because of that, because they're using marijuana. Perhaps there are other nitty-gritty semantics, loopholes, what have you, to get around this, and we'll have to see and put our minds to it and come up with inventive solutions for provisions like the ones we see here in Maine. But no doubt, this is going to make drug testing, pre-employment drug testing, a little bit more hairy in Maine. And like we say over and over, we'll have to see how this plays out and evolves. So moving on, Massachusetts, question 4. The chapter shall not require an employer to permit or accommodate conduct otherwise allowed by this chapter, meaning smoking marijuana, in the workplace, and shall not affect the authority of employers to enact and enforce workplace policies restricting marijuana use by employees. So again, this is kind of a more succinct version of what we've seen in other marijuana laws from 2016. You know, we've got that in the workplace caveat for, you know, use and nation. But we also see employers are not required, still have authority to enforce workplace policies that restrict marijuana use. And restrict, prohibit, in my mind, restrict something 100%, right? So we have to see, as this is out, whether we keep a common definition of restrict or we have to make up a new definition of the word restrict. In Nevada, you know, what happens in Las Vegas stays in Las Vegas. Well, the marijuana law in Nevada seems to be the opposite of the live and let live mentality that we see in Nevada. It says a public or private employer, nothing prohibits a public or private employer maintaining, enacting, and enforcing a workplace policy prohibiting or taking actions or conduct otherwise permitted, aka smoking marijuana. So while all these other states that are necessarily known for being kind of live, wild, do what you want states, you know, go away and use the word prohibit. Nevada, you know, in the word prohibit to its medical or recreational marijuana law. Thus, there's no debate about restriction versus prohibit. It's just employers can prohibit use by its employees. So while it doesn't mention drug testing, having a free workplace is absolutely 100% in law, and you know, and that includes drug testing for many employers, drug-free workplace policies. So, real quick, the Arizona Prop 205 got a lot of attention leading into November, and you know, if we go back to the pufferfish analogy, it was definitely the biggest of the pufferfish going into the November election, with very threatening language that made it sound like it was putting, you know, down on any chance of doing drug testing. Well, in reality, if you read the law very carefully, it was not as tough as it made itself out to be. Though it didn't pass because it caused a lot of confusion for a lot of people who would have thought that, you know, they immediately needed to remove marijuana from their drug testing program. That wasn't the case. But we have some lessons we can learn from this, because the pro-marijuana people were extremely well organized, especially in Arizona. If you looked at, you know, the funding and the advertising and the marketing that from the pro-legalization people in Arizona, I'm not on sides at all, but it did kind of make the marijuana movement seem very limited in comparison. And so then things that we can learn from that. And I think the number one thing for us is information over cliche. And so there's a cliche of what someone think of the children, right? So the marijuana movement has cornered the market on emotional appeal. Perhaps it would be more effective for us as a drug testing industry. Instead, I think of the children, you know, and that's an example. It's generalization. I'm not pinpointing or any specific argument, but instead of those emotional appeals, look at data. Child marijuana poisoning in Colorado has been up since legalization. And the number one is something like 60% of marijuana poisoning of children in Colorado is due to edibles. So kids are getting their hands on mom and dad's or mom and boyfriends or dad and boyfriend, or girlfriends, gummy bears, and they look like me, so they eat them. Brownies, cakes, chips, whatever it is. These things are just sitting out, and they're getting them, and they're getting poisoned. Instead, there to prove it. Another cliche: pot makes you stupid, or weed makes you dumb. Well, the truth of the matter is, research from all over the world shows us this. Marijuana impairs memory. So I'm from Chicago, and Northland University in my hometown here put out a study showing that it impairs memory. University in the Netherlands has a report showing that marijuana hinders creative problem solving. They gave people marijuana and some people a placebo, and then gave them, complex problem solving scenarios. And the people taking the marijuana were not as able as those taking the placebo to figure out a solution to whatever problem it might have been. The University of Queensland in Australia had, released a study showing that marijuana does in fact kill brain cells. So again, it's like raccoon versus the wolf. Maybe marijuana doesn't kill as many brain cells as nicotine, but you still don't want the raccoon in your house. You still don't want, teenagers taking marijuana because it's, in edible form, and they can get it out of mom and dad's kitchen cabinet. And here's another one. Maybe this isn't such a cliche, but marijuana users are dangerous drivers. We just say it, and maybe saying it's not enough. We need to back that up. And like we just looked at that trip data came out in 2016, we have Washington showing that fatal car crashes involving marijuana users has more than doubled since. And if that trend continues when the 2015 and 2016 data becomes available. Lesson, at least in my mind, lesson that we can learn from Arizona Prop 205, as a drug testing industry, how are we mobilizing ourselves, informing ourselves, and then taking that information, that mobility, and it as a concentrated, organized movement to the other side of the story. Because there's no way around it. There's with the sick children, I sympathize with them 100%, and it pulls on my heartstrings. And that's where the legalization movement has excelled, is those emotional appeals. So what can we as an industry do? And I think this is one of them. In the comments, if you've got any other suggestions for what we can do as an industry, send them in the chat, or send them to me, consulting group or Orshire, and see what we can do as an industry. Short on time, I'm going to go quickly through these other marijuana laws. We have amendments to existing marijuana laws in Alaska, California, District of Columbia, and Michigan. And these laws can change at any time. We saw Louisiana pass a medical marijuana law, but because it doesn't add protection for providers, the pro-legalization people have said it's not a true, legitimate marijuana program. They don't count it. And go to any website, procon.org, or any of the pro-legalization websites, they don't count Louisiana. But this law actually passed last year. So we could technically say 10 states approved marijuana or recreational marijuana last year. Nebraska passed the law, but the rules in Nebraska, legislation has to be voted on and approved 3 different times. So it got voted on and approved the first time, it got filibustered during the second time. So it died there, but it technically passed once. So they're 11th state this year. Something really quick over right to try laws. And this comes from the Right to Try movement's website. So people are very put off if you use other, if you use the pro-legalization search, and and this is, they've already had it here, so I'm just going to use it. I'm not taking a stance on it, but what they say, all the green are the states where they have passed right to try, meaning it's what's legal or not, a sick person has to try marijuana. That's what the laws say. The blue states are states where a law has been introduced. The gray is where nothing has been introduced, and red, there in Hawaii, it was passed but vetoed. 2016, these states, California, Connecticut, Idaho, Maine, and West Virginia, all passed right to try laws. It's interesting, even in California, where medical and recreational marijuana are already on the table, I guess tripling down, not just a double down, but a triple down on, marijuana by passing this right to try law. And so in the next 3 to 5 minutes, we're going to do a flyby, my overview of the OSHA injury reporting and implications. So this went into effect December 1st, originally scheduled for October 31st, pushed back to November 1st. There was talk of an injunction, but on November 29th, we learned that the injunction had been delayed and implementation would not be delayed any further. Injunction does not mean that the court is ruling in favor of the OSHA injury reporting rule. It means that they don't see any reason why there should be an injunction. So the injury reporting rule goes into effect, or went into effect December 1st, and still be ruled upon by the judge later, most likely in 2017. So there's reasonable basis for employees to report a work-related injury or illness, and it requires employers to not discriminate or retaliate against those employees who report an injury or illness. And so it's kind of learning a foreign language, like Spanish has certain vowels that we don't have in English. So here a Spanish vowel, we might just state it with the English vowel. Well, same way with drug testing. We've got these terms and conditions that we're used to hearing in the drug testing industry, and we hear something very similar in these OSHA regulations, and so we just kind of translate it. What OSHA regulation is not, though, is not a post-accident drug testing law. And I was talking about injury reporting, and we really talk about injury reporting that often in the drug testing industry. We talk about post-accident drug testing, so it's so similar. It's like associated that vowel back into something we are familiar with in drug testing. It's not a post-accident drug testing regulation, and that's important to keep in mind. Seeing over the rationale, we look at, this comes from an October 19 memo that OSHA sent out to clarify how it intends to implement the rather vague and open-ended regulation that it created for reporting injuries. So evaluation of reasonableness of drug testing will consider these factors. One, whether the employer had a reasonable basis for concluding that the use that drugs could have contributed to the injury or illness that was reported. The results of the drug test could provide insight into why the injury or illness occurred. Whether other employees involved in the incident that caused the injury or illness were also tested. The employer only tested the employee who reported the injury. That could be an issue of retaliation for reporting. And third, whether the employer has a heightened interest in determining if drug use could have caused or could have contributed to the injury or illness to the hazardous nature of the workplace. So basically safety-sensitive workplaces. So if these things fall into place, then even if there is some question brought up with OSHA, they will not find a violation of their injury reporting regulation. They won't find drug testing as a punitive retaliatory action against someone who reports. So, and the preamble to the rule had been about drug tests must be able to indicate impairment. This is an excerpt or a summary of that original statement. In the October 19 memo, they added this: "I will only consider whether the drug test is capable of measuring impairment at the time of the injury or where such test is available. Therefore, OSHA will consider this factor for tests that measure alcohol use, but not tests that measure the use of any other drugs." So while, the science has been accepted that we can determine impairment with analysis, but it's not quite there yet, drug testing, so OSHA will not use that as a criteria when evaluating a drug testing program. When it becomes available, though, that will become an imperative for employers to use those types of drug testing. So if we have a couple examples, like an accident, a crane accident, different criteria for when that would be acceptable and when it wouldn't. For example, if we look at the next page, if an employer only tested the crane operator and not the other people involved in the accident, that would be violation. Or testing for an injury, someone reports an injury that couldn't be caused by an accident or couldn't be caused by drug use, like repetitive strain or a bee sting. So, like we talked about earlier, employer motivation is the key. Implementation of a safety rule is good to go. Following an injury reporting system to go. Compliance with the drug-free workplace policy, good to go. Retaliating against someone who reports an injury or an illness, that's when it becomes a problem. So the number of things, since we only got a couple of minutes left, that I could say, and prepare yourselves for, if you haven't it, is to create a decision tree and be able to document clear indicators that establish a reasonable possibility of drug use contributing to an accident. Did they meet the definition of the outlined by the company policy? Was the employee involved in an activity that could have caused or contributed to the accident? Did the action or inaction contribute to the accident? Is there no probability that drug or alcohol impairment could have contributed to the accident? Did an active guard equipment failure or other occurrence be employee's control contribute to the accident? And depending on the answer that you document in this decision tree, that is going to create kind of the safe path towards post-accident drug test. A few other kind of best practice recommendations that we can give you. And out of 1,000 miles per hour, review your policy, review state laws. Again, if you're complying with state law, then your motive is compliance, not retaliation. Decision tree, consider post-accident reasonable suspicion training for supervisors. And we always add this in, consider lab-based oral fluid testing because of the unique time window of detection that it offers. It offers that close kind of 24 to 48 hour window detection. It does show you drug use from a week ago, which wouldn't have anything to do with the accident. It shows you drug use from yesterday and today, which absolutely could have contributed to today's accident. So, last point, items for 2017. Here we have a couple of links, usa.gov/elected-officials. Go here for links to access federal and state officials' contact information, or congress.gov/state legislature website. And this is an interactive map. You click on your state, and it tells you who lawmakers are, what their address is, what their phone number is, and then gather information, a letter, send it in to them, and make the case for a workplace and why we need to defend a drug place and drug testing and keep our workplaces safe. Even if you're feeling up to it, come in person. They have the phone number. Call and make your argument to them over the phone. Because, you always hear them speaking at rallies and they say, I was just talking to someone from the district. Well, that could be you to talk to, and that sticks in mind. Of course, there are services like currentcompliance.org, which we do current consulting group. It's called up, it's our legislative update, and then we provide that to subscribers so that they know ahead of time what laws are going on. So instead of waiting till December to get this briefing that we make, our subscribers know what's going on from week to week. So with that, we're out of time for questions, but we've received them. I would just like to say thank you for coming on and listening today, and I'll turn the time back over to Jessica.
Drew, and on behalf of OraSure Technologies, we hope you have found today's webinar presentation informative and helpful. The presentation was recorded, and you will receive instructions informing you how to access the recording. Thank you for attendance today. This concludes today's webinar.